In this video, I'm going to walk you through 5 lies your CPA told you about Florida LLCs. And by the end of this video, you'll know exactly where their advice falls short, how to protect yourself, and what to do instead. Hi, I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years cleaning up the legal messes that bad LLC advice creates. So let's get into it. Look, I get it. You trust your accountant, and you should. But when it comes to Florida LLCs, most CPAs are giving advice that is flat out wrong. Not because they're bad people, but because they're not lawyers. They're looking at your business through a tax lens, and that's where the real problem starts, because that tax-only mindset leads straight to the first big myth Florida business owners believe. And here it is, lie number 1. You don't need an operating agreement. And this one drives me nuts. And I hear it all the time. A business owner sits down with their CPA. The CPA helps them file the articles of organization with the state. The LLC gets approved, and then the CPA says something like, all right, you're all set, you're good to go. No, you're not good to go at all. Filing your articles of organization is like buying a house with no lock on the doors. Sure, you own the house, but you have zero protection. Now, your operating agreement is the backbone of your LLC. It spells out who owns what. It defines how profits get split, and it tells you what happens if a member wants to leave. And it lays the groundwork for how disputes get resolved. Without it, you're operating under Florida's default LLC statute. And let me tell you something, that default statute was not written with your best interest in mind. And here's the scary part. If you get sued and you don't have an operating agreement, a judge could pierce your corporate veil. That means your personal assets are now fair game. Your house, your car, your savings account, all of it exposed. Your CPA doesn't tell you this because drafting an operating agreement is not their job. It's a legal document. It needs to be done by an attorney who understands Florida business law, period. Now here's lie number 2. A single member LLC gives you full asset protection. And this is one of the most dangerous myths out there. And CPAs repeat it constantly. And yes, a single member LLC does give you some level of separation between your personal assets and your business. That is true. But some level is not doing a lot of heavy lifting in that sentence. In Florida, single-member LLCs do not receive the same charging order protection that multi-member LLCs get. So, all right, so what does that mean in plain English? It means that if someone sues you personally, not your business, but you, a court can potentially reach into your single-member LLC and grab those assets. With a multi-member LLC, creditors are limited to a charging order. That's basically a lien on your distributions. They can't seize the LLC itself. They can't force a sale. They just have to wait. But with the single-member LLC, Florida courts have shown a willingness to go further. That's a problem your CPA probably never mentioned. Now, does that mean a single-member LLC is worthless? Absolutely not. But it still serves a purpose. But you need to understand its limitations. And you might need a more sophisticated structure to get the protection you think you already have. All right, lie number 3. You should elect S-Corp status for your LLC. Oh, this is a big one. This is the lie that CPAs love to tell because it saves you money on self-employment taxes. And look, in some cases they're right, but in many cases they're not. And the consequences can be severe. All right, here's what happens. Your CPA sees that you're making good money through your LLC. They tell you to elect S-Corp status with the IRS. You file Form 2553. Now you can pay yourself a reasonable salary and take the rest as distributions. You save on FICA taxes. Everybody's happy. Except no one talked about what that election does to your legal structure. When you elect S-Corp status, you're now bound by S-Corp rules. That means restrictions on who can be a shareholder. That means only one class of stock. That means no foreign owners And that means you can't have more than 100 shareholders. And if you're planning to bring on investors, well, you just handcuffed yourself. If you want to do business internationally, you may have just created a nightmare. If you want a flexible profit sharing arrangement, too bad. S-Corp rules won't allow it. Now, if you're getting value from this video, do me a favor and hit that like button. And if you haven't already, subscribe to this channel. I put out content like this every week to help Florida business owners protect themselves. All right, let's keep going. Now, your CPA ran the tax numbers. They did their job, but they didn't run the legal analysis. And the tax savings might not be worth the structural limitations you just imposed on your company. That's a conversation you need to have with a business attorney before you file that election, not after. Right, lie number 4. All you need is an EIN number and you're protected. I can't tell you how many clients walk into my office thinking their EIN is some kind of magic shield. Their CPA helped them get it. They filed it with the IRS. They had the confirmation letter framed on their wall, and they think they're bulletproof. An EIN number is simply a tax identification number. That's it. It identifies your entity for federal tax purposes. It does not create legal protection. It does not separate your personal assets from your business. It does not make you compliant with Florida law. Here's what actually protects you. Proper formation documents, a well-drafted operating agreement, maintaining separate bank accounts, keeping accurate records, holding yourself out as an LLC in every contract, every invoice, every piece of communication, following the formalities. This is what protects you. I've seen business owners who had an EIN number, had a business bank account, and still lost everything in a lawsuit because they commingled funds, because they signed contracts in their personal name, and because they treated the LLC like it didn't even exist. Your CPA got the EIN because you needed it to open a bank account and file taxes. That's their lane. But legal compliance, that's a completely different conversation. And it's one too many business owners never have until it's too late. And lie number 5, you don't need a registered agent. Just use your home address. This one sounds so harmless. And on the surface, it kind of makes sense. Why pay for a registered agent when you can just use your own address? Well, here's why. First, your registered agent address goes on the public records. That means your home address is now searchable by anyone. Creditors, competitors, disgruntled customers. Anyone with an internet connection can find where you live. And in today's world, that's just not inconvenient. It's a legitimate safety concern. Second, your registered agent is responsible for receiving service of process. That's legal speak for getting served with a lawsuit. If you're traveling, if you're on vacation, if you simply missed the delivery, you could default on a lawsuit you didn't even know existed. And that has real consequences. A court can enter a default judgment against you, and you lose without ever stepping foot in a courtroom. And third, using your home address looks unprofessional. It looks like you're cutting corners. And if you ever end up in litigation, opposing counsel will use that against you. They'll argue you weren't treating your LLC as a separate entity. And that argument carries a lot of weight. A registered agent service costs a few $100s a year. That's it. It keeps your personal information private, and it ensures you never miss a legal filing. And it adds a layer of legitimacy to your business. Your CPA told you to skip it because they were looking at the expense line. But sometimes the cheapest option is the most expensive mistake you can make. So there you have it. 5 lies your CPA told you about Florida LLCs. Now, I want to be clear. Your CPA is essential to your business. They handle your taxes. They keep you out of trouble with the IRS. But legal structuring, that's not their wheelhouse. If anything in this video made you rethink your LLC setup, take action. Talk to a qualified business attorney and get your operating agreement reviewed. Make sure your structure actually does what you think it does. Now, if this video helped you, hit that like button, subscribe to my channel so you don't miss the next one, and share it with a friend who owns a business in Florida. They need to hear this too. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.